Oh, hey. Alrighty. So today we're going to start diving into civil assessments. Reminder that by midnight tonight, your midterm is due, the short answers. And you just turn it in on Blackboard. And again, this is the part of the class that's the most me talking. So thank you for bearing with me. We will get to more interactive stuff next week, I promise. So let me go ahead and do a couple things here. Turn on our captions. Go on into slideshow mode.
It was due tonight.
Yeah. Yep. Just making sure I didn't miss anybody here who signed on Zoom before I minimize here. Alrighty. So civil assessments, here is where we are going to start talking about how we get involved in non-criminal cases. So in some cases, this will be lawsuits. In other cases, this might be divorce or child custody cases, things along those lines. There are a whole bunch of different ways that psychologists may be asked to be involved here. And we're going to start by talking about domestic relations. It's one of the most frequent ways psychologists get involved. And indeed, there are some psychologists that this is almost their whole job, basically. So this is the civil branch of the judicial system. There's no juries here. Everything is made by the judge or by an assistant acting for the judge. So in some jurisdictions, there are referees or magistrates. And these are folks who can do everything but sign off. So they can essentially make decisions on the case. And then just a judge would have to formally sign the document. Hang on just one sec. Let me make sure everybody is muted. Looks like yes. Okay, good. So if you go to a lot of family courts, what you will see is actually magistrates deciding these cases. So these are folks that this is their job, they just are not technically full judges. These decisions are technically appealable, but it rarely is done. It's unlikely that these decisions would be overturned. And typically, if you do appeal them, you're going back to the exact same judge. So, or say magistrate. So you're probably not going to get a different answer unless there's drastically different new information that comes up. And so custody evaluations are a big piece of this. And so these are when parents are separating, parents are divorcing, and you're trying to decide who gets custody of the kids. And there are different types of custody. So legal custody is where you can make decisions related to the child and you are responsible for the child. So the person who has legal custody would be the one who can make medical decisions, for example. Physical custody is where the child actually lives. And so there are scenarios where perhaps there's split physical custody, right? but only one of the parents has the legal custody. Joint custody is where each parent has an equal authority to make decisions about the child. And it's possible to have the child primarily have physical custody with one parent, but then have what's called visitation. So this is access of the non-custodial parent to the child. Most courts have standard visitations, and this will vary from area to area to sort of what the judges like. So for example, Jack told us that, people who had visitation in the jurisdiction he'd done stuff in they would get visitation Tuesdays and Thursdays from 6 to 9 p.m. and then every other weekend from 6 p.m. Friday to 6 p.m. Sunday. So that's an example of visitation rights. You can also have temporary versus permanent custody. So temporary custody would typically be while the proceedings are going on, while the final decision is being made. And interestingly, and this is at least sexist against everyone involved, the kids are almost always given to the mother. And this is very problematic because what if the mom is the one who's the abusive one, right? And so a lot of both men's rights activists and feminists have really been advocating for fathers who want to be involved in their children's life to be able to get this type of custody more frequently. During that temporary custody, whoever does have custody has the right to make decisions about the kids. And this is often even though the marriage is still intact. So if you're going through divorce, during the divorce proceedings, one parent, again, typically the mom, will get custody and they can make decisions about the kids without having to consult the dad. There's also permanent custody, although permanent is sort of a misnomer. It's never actually permanent. After 12 months, any custody question can be reopened, or it could be reopened at any time if the kids are in danger. So let's say one parent is a psychopath, when they really pulled the wool over the psychologist's eyes and the judge's eyes, and you find out, 2 months in, this person is abusing their kids. You don't have to wait 10 more months. You can go to court and say, this child is in danger, we need to switch custody. Now, in terms of statistics, for some cohorts, 40% of marriages end in divorce. For a long time, it was 50%. I think one of the reasons this is adjusting is a lot of Gen X, millennials, Gen Z are just not bothering getting married. I mean, they're like, whatever, we can just live together. We don't need a formal certificate. So then those wouldn't be documented when there are separations. About a third to a half of couples who do go through a divorce have kids under 18. So if the kids are over 18, custody is not an issue, right? But if the kids are under 18, then we do need to take a look at that. And those come under the jurisdiction of the domestic relations court. And custody itself must be approved by the court. Therefore, most divorcing parents, about 70 to 90% of divorcing parents reach an agreement about custody. Either one parent's like, I don't want custody at all, or they're able to sort of amicably say, we'll split custody, here's the schedule we're going to use. So that's 70 to 90% of divorcing parents. So mental health professionals are not involved in the vast majority of custody cases, even contested ones. Psychologists get involved in the toughest cases. And they get involved to try to help the trier of fact, whether that's the judge, the magistrate, the referee, make those tough decisions. In turn, attorneys and judges typically do not place great value on mental health testimony in custody cases. Instead, what they look at is the report you write. So you give them the report, they read it, they go based off that. It's very rare to testify in these particular cases. So what is the justification for psychologists getting involved in this at all? Why are mental health professionals getting involved in custody cases? Well, there's a couple legal justifications. One is the Uniform Marriage and Divorce Act of 1979. And this is a set of guidelines made up by a group representing all 50 states. And custody decisions are made in the best interest of the child. The best interest of the child is the guiding principle. And that's based on a number of factors. And one of the factors they list is the mental and physical health of all the individuals involved. So the mental and physical health of all the individuals involved, that justifies the involvement of mental health professionals in this process. And so when you're making a decision about the best interest of the child, you're going to look at the wishes of the child, obviously, the wishes of the parents, the interaction of the family, and what the child's adjustment is like, not only in your office, but also how are they doing at school, how are they doing in the community if they're playing soccer or something like that, and how are they doing at home. Then there is the Michigan Child Custody Act, which was originally made in 1970, revised and renewed in 1993. And this is the model for basically all the other state laws and standards. And so they really broke down what the best interest of the child mean. And so it included things like love, affection, and emotional ties between the parent and the child. Okay, we can see some psychological things involved there, right? The capacity and disposition of the parents to give the child love, affection, guidance, and continuation of education. And if they have a religion or creed, continuing to raise the child within that. Capacity and disposition to provide the child with their basic needs, food, clothing, medical care. Length of time the child lived in a stable, satisfactory environment, and desirability of maintaining continuity. And this becomes really critical in a lot of cases. The court is typically reluctant to interrupt a parent-child relationship that's going well. So if mom was granted temporary custody and the kids are thriving, we're not going to say, oh, dad gets full custody, right? We'll probably work on some sort of visitation if dad is interested and basically acceptable, not going to harm the children. Permanence as a family unit of the home, moral fitness of both parties, and again, the language physical and mental health of the parties involved. So again, where psychologists come into play, the home, school, and community record of the child, the reasonable preferences of the child, and the court will sort of look at the child's age as part of this. Is the child of sufficient age to express a preference? And willingness and ability of the parents to encourage close parent-child relationship between the child and the other parent, again, where appropriate. And any other factor that the court considers relevant. So that kind of opens up a can of worms, right? But so those relationships and then the mental and physical health of the parties involved are how, again, psychologists get involved in these cases. Now in custody evaluations, the goal is to provide information to the court to help in determining custody and visitation arrangements. And the goal with the custody and visitation arrangements is that they will most likely assure that the child's present and future needs are met. So not only are you trying to determine what's best for the kiddo now, you're also trying to help predict what will be best for them in the future. So you are going to provide information, and this can take on a lot of different forms. And again, typically, this is going to go to the court in a report. And typically they will take that at face value rather than coming to ask you to testify. And again, trying to assure that future and present needs are met. They need to find out what the kids need. So if you all were just thinking like, what does a child need to do well now and in the future? What are some things you can think of? Yes.
Oh, no.
Oh, that's good. There's really kind of no wrong answers here. So any stabs in the dark y'all might have are good. So what would a child need to live a good life now and in the future? Yeah. Housing, big one, right? If one parent is homeless, probably not gonna get custody. Emotional support, huge one. Were you gonna say the same thing? Yeah. So lots of different things, right? And so there are some universals here, things we just talked about, right? Housing, safety, education. Are they gonna have access to an education? Can that parent make sure they get to school? Love, security, stability, guidance. Then there are some unique ones to whatever situation that particular family is going through. So, what can end up being problematic is you might have kids within the same family who have different needs. And so sometimes you'll have split custody, right, where one parent will be the custodial parent of one child, the other will be for the other child. They usually know about each other, though. It's not like a Lindsay Lohan Parent Trap moment. I don't know if that reference might be too old for y'all now. I don't know. But other things they look at here are like, does the child need special education? Do they have a physical disability, developmental delay? Do they have particular medical treatment they need? Psychological treatment? Is there a particular parenting style necessary that one parent has more than the other? And then the future. What will the kids need as they get older, and can that parent provide that going forward? So possible roles for psychologists here. Some people argue psychologists shouldn't be involved. There's no role for psychologists here. That psychologists have nothing special to offer. But that's really hard to argue when we know that mental health is part of the criteria. So most people disagree with us. Some say that the psychologist should serve as an investigator and report facts only, not offer any opinion. Some say that they should offer opinions about certain factors identified in child custody statutes. So for example, they could offer opinions about the mental health of everyone involved, right? But some people say they should just stop there and offer no opinions about custody arrangements. Some argue that psychologists should offer opinions about the ultimate issue, about custody and or visitation arrangements that are in the best interest of the child. And psychologists, especially those who specialize in this, would argue that they are in fact the most qualified to do so. But in most cases, the court will determine the role that the psychologist will have. The court will sort of instruct them whether or not they can advise on the ultimate issue. And obviously the court is going to make the final decision on custody, whatever the role of the psychologist will be. One of the really important pieces here is that the assessor needs to be competent to assess the needs of children. So for example, I would feel completely unqualified to do these type of evals because my PhD concentration area was adult psychopathology. So I didn't treat kids, I didn't study kids beyond like one class in grad school. If anyone ever called me up in court and questioned my credentials, it would be pretty obvious I shouldn't be doing this, right? So people should have ideas. People who in my same program specialized in child clinical took a lot more classes than we did because they had to understand what's normal and abnormal at each age, right? And what's the range and things along those lines. So the APA, the American Psychological Association, does offer guidelines in conducting these types of evals, which is helpful. That's good. And these are particularly for custody evaluations during divorce proceedings. And the purpose of the evaluation is to assist in determining the psychological best interest of the child. So again, that's going to come up over and over. What's in the best interest of the child? The child's welfare is paramount. It's the most important. And the evaluation is going to focus on parenting attributes, the child's psychological needs, and the resulting fit between those two. So you're going to start with the needs of the child and then look at the related parenting characteristics and what is the best fit for that particular child's needs. And from what I've understood, you're talking to both Jack Graham, who taught me this course in grad school, who's done these, and then also my grad advisor, who did some of these as well. It's usually, unfortunately, there's no perfect solution. You're usually kind of looking at the best fit, the lesser of two evils. Psychologists strive to gain and maintain specialized competence in order to do these. So they have specialized training. They'll continue to engage in continuing education training, especially as, say, laws change and they need to be aware of the laws. However, there's no like, this is what you have to do to be competent. It's sort of the psychologist decides for themselves who or what is competent, essentially. Psychologists also strive to function as impartial evaluators. They're supposed to go in sort of blank slate, looking at everybody equally. Now, this can be really hard, right? Because we all, even if we don't want kids ourselves, tend to have heartstrings tugged for the kids, right? And if the kid tells you something about a parent, your gut is to like immediately dislike that parent, right? But you kind of have to like give the benefit of the doubt, and expect that perhaps, you know, that you should let the parent tell their own story. That's the best way to say it, essentially. So it's legitimate to describe each person and their personality characteristics, but the psychologist has to monitor their own values and perceptions as they go forward. And psychologists strive to engage in culturally informed, non-discriminatory evaluation practices. And so this is again where cultural sensitivity, but also continuing education come into play, right? If it was me, I'm obviously super white, we can see how pasty pale I am, right? And I was evaluating a family from a culture I wasn't familiar with, it would be on me to research norms for that culture and understand about them, ideally before I even worked with that population, but also to ask the family members what is normative, with not only within your culture, but within your particular family. Psychologists also strive to avoid conflicts of interest in multiple relationships. So obviously you don't want to do child custody evaluations for a family member or a friend. That is not good, right? But you also can't do one of these assessments if you're already the therapist for one of the people involved, because then you're already affiliated with that particular person. So like if I was seeing the mom as my therapy client, and she was like, oh, can you do this custody evaluation? I have to say, no, you need to go to an impartial third party. This is actually in general, not just particular to custody cases, but the most common violation of the APA ethics code is this like multiple relationships. And this is particularly hard for folks who live in small communities. So let's say you live in a small rural town, you might be the only psychologist there, right? And then you have to decide, like, when is a conflict of interest actually a conflict of interest? Is it, you know, your hairdresser, right? Do you know them too well? Is it like the guy who changed your oil once, right? And so that gets trickier when there's only one guy who changes the oil and one person who cuts hair, right? I would say for sure you don't want to tick off either of those people if you want to look good and you want to be able to get from place to place, right? So then you might be looking for folks outside your jurisdiction. And the nice thing is, I mean, again, like I hate to say anything good has come out of the pandemic, right? But a lot of courts and a lot of psychologists have started to be more open to telework and telehealth. And so it's much more feasible to get someone from outside your area to do the eval in that point in time. I know a lot of like child custody cases are still being done partially via Zoom, for example. Psychologists also have to establish the scope of the evaluation within a timely manner. So you get the referral, And you have to decide, okay, who all do I need to contact? What all information do I need? So you're obviously always gonna interview both parents and all the kids. But sometimes there's gonna be others you need to interview. Are grandparents heavily involved? Do they have a nanny? Right? Who has been witness to these dynamics? Or who else might be trying to get custody? I have someone I know who, I think it was her husband's parents tried to get custody of their kiddos because their husband was starting a marijuana farm when it was legal in the the municipality that they were living in. But they were like, oh, that makes it an unsafe environment for the kid. To like grow some plants, right? Like it's not like they were smoking it in front of the kids. So yeah, grandparents can get involved, other family members can get involved at times as well. And it's best if everyone you evaluate is court ordered to do so. If people are court ordered, they will comply. They might comply begrudgingly, but they will comply. If they're not court ordered, then they don't have to.
I've only seen saying this because I've seen this, but there's also cases where the grandparents intervene if the parents separate and one of the parents ends up being there. I've seen that before.
Yeah, and that's,
The grandparents try to take the kid away
I
or
could see that.
finance the other parent to get custody.
Yeah, and thank you so much for bringing this up. This is a big issue that people think, oh, well, we have marriage equality, so therefore gay rights. We have some gay rights, right? We have some rights for the LGBTQ plus community, but in a lot of places, they don't have the right to adopt. Or their rights can be called into question during custody proceedings. In a lot of states, I think Virginia might have finally changed this a couple of years ago, but it was true in Virginia at least as like 3 years ago. A lot of states you can be fired for being gay or being trans. Because they're considered right to work states, which is a really silly misnomer for you can get fired at any time for any reason. So yeah, this is a good example. And certainly before marriage equality, I mean, it would get extra complicated, right? Even now, whether it's a LGBTQ plus or a straight couple, if someone has a previous kid or like they adopt together, like both parents better adopt, right? Or you like adopt the kid from previous marriage, otherwise essentially all your rights are out the window if you divorce. So yeah, thank you for bringing that up. And heartbreaking, right? And sometimes the grandparents step in for good reasons. I want to say that too, right? If both parents are abusive or both parents are like completely unable to take care of the child because of their own mental or physical health issues or substance abuse issues, then the court does try to find other family members if they can. Actually, Olympic gold medalist Simone Biles was taken out of the foster system by her grandparents. I don't think she ever knew her dad. Her mom had a drug issue, and so her grandparents took her and her sister. And then she calls who are biologically her grandparents mom and dad now because they raised her. So certainly there are times where that's a better situation. Let me see what else. You also strive to appropriately obtain informed consent. So for the adults, you need a signed consent form. Adults also have to sign one on behalf of the child. And then you should get what's called assent for the child, which is where you verbally explain in language they can understand what's going to happen. And same thing as some of these other assessments we've been talking about, you want to make sure they know this isn't like going to therapy. What you're telling me is not confidential. It's going to go in this report to the court. They also strive to employ multiple methods of data gathering. So not only interviewing everybody, doing standard psychological tests, but also doing record review. And they'll also have parents come in and do observations where they watch the kid and the parent interact. Yeah.
Sorry, I have another question.
Sure.
In cases where the child is being abused and stuff, do psychologists give the children like a level of confidentiality? That really doesn't exist.
Yeah, that's where this gets really hard, right? So, no. We actually like legally can't, even if you're not in a court case. And so this is something that even if you're doing a therapy case, you tell people right off the bat, there are certain things you would tell me that I have to break confidentiality for because I'm a mandated reporter. So if a child, an elder, someone who's developmentally delayed, who can't care for themselves is being abused, that's one of those situations. It's one of the few times you have to break confidentiality. So yeah, unfortunately, even though, yeah, it could get scary for that kid, right? But essentially, as the therapist, if the kid discloses that to you, especially if you work for the court system, the really nice thing is like CPS is probably pretty close by, right? And so you would get them involved right away. Essentially try to get the child out of that environment right away.
Wouldn't that be more harmful though, because there are cases where that has been the death of the child?
Yeah. Yeah, and that's why that is really hard as a therapist, to be honest. And that's why, again, trying to get them removed from that environment as soon as you know, becomes really important. And there are times that gets sticky, right? So for example, we had a case when I took my professional issues and ethics class, one of the women the year before me, she had a case where this man had abused his daughter growing up sexually. And then he wasn't doing it anymore, but he was the principal at an elementary school. And so it's like, do we report him at that point in time? And I believe they actually called like the APA ethics office to get a consult from them. And they basically said, like, if there's no evidence he's abused anyone but his daughter, then no, right at that point. But certainly something to kind of like be monitoring, obviously. So yeah, it can get really complicated, obviously. And then like sometimes both parents are complicit in the abuse, right? And then when there's no family around, so then the kid goes into the system, and we know that's not always the greatest. So yeah, it's really, really tricky. And that's why these can be really hard for psychologists to do and can feel like no-win situations. Yeah. So yeah, you want to make sure people understand that, right? Because I mean, you don't want them to lie or withhold information, but if it's going to make them unsafe and they make the decision not to tell you, we understand that, right? I mean, even as a therapist, I've had people like, I tell them that and then they disclose to me within their intake interview that they abused someone. And I'm like, okay, wait, remember that talk we had? But I've only had people who were not like actively abusing. So then again, if it's not going on, you don't have to report it. But I can imagine there are people who just, yeah, I'm abusing my child, right? And yeah, you gotta call. You're legally and ethically bound to do so. Let's see what else. So yeah, making sure they understand that. You want to make sure that you are using all the appropriate sources of information. And you also want to interpret the data in a manner consistent to the context of the evaluation. Right, so if you find out one of the parents has major depression, but that's not affecting their way, the way that they parent, they're still being a really good parent. Like, yeah, you'll mention it, but you'll make sure in your report you say, this is not impeding their ability to act as a parent, right? Not just, oh, they have a mental disorder, so they can't have custody. You also want to strive to complete the evaluation and complement the evaluation with the appropriate combination of, again, like well-validated instruments and examinations. And you strive to base your recommendations, if any, on that psychological best interest of the child. And you also have to create and maintain professional records in accordance with ethical and legal obligations. So this essentially means you write everything down. And you get additional permission to do so, but you typically would also document things either by audio or video as well. So if you're having them come in for a parent-child observation, you would get their permission to, but then you'd video record them. I've been told that even though people know they're being observed, you will see some stuff that you're like, what do they do when they don't know they're being observed, right? So that can be really telling. Now, and how to actually do the eval itself. The first steps are to evaluate the child's needs. So again, what does this particular child sitting in front of me need over and above the typical safety, shelter, emotional support that we talked about earlier? And then you're going to evaluate the relevant characteristics of parents and other significant adults in their lives. And in particular, those characteristics that bear on parents' capacity to meet the needs of that particular child, right? There are parents who would be excellent parents in general, but who don't believe autism exists. And there's a kid who's on the autism spectrum. That parent should not have that child, right? If it's an option. You also want to match the child's needs and capacities to significant others that might meet the child's needs. So this is the hard part because, again, as we've mentioned previously, sometimes this is neither parent. Neither parent are going to match the child's needs. So then again, you're looking, are we sending them into the foster care system? Is there another family member like a grandparent, right, who could step into these needs? So then you are going to do some of the same steps, honestly, that you do when you do some of these other evaluations we talked about. So even though this is a civil, not a criminal investigation, you are going to do very similar steps. So you're going to interview everybody involved, anyone who has a relevant role. The kids, the parents, again, grandparents, other family members who might be involved. And then you're even going to interview folks like their kids' teachers, the therapists, and, you know, doing that over the phone if you can't get them in or to try to save them time. And then you'll do an observation in your office for practical reasons. And as I just mentioned, parents will often be on good behavior, but some will not be able to hold it together even in this short time while they know they're being watched. And so they'll hit their kid, yell at their kid, things like that. Obviously, that gives you some pretty good evidence. So then through your observation, you will form impressions of the parent-child interactions. And then you're going to do a records review. You're going to look at how is their school performance? Have they been in therapy? Has the kid themselves had any legal issues? Have the parents had any legal issues? Things along those lines. And so you want to collect everything that's relevant within the time limits you can spend on the evaluation, right? You can't spend months and months and months working on these evals, right? Because the court needs it by a certain time. So you try to get what you can. Oftentimes the parents will also want to provide you documentation themselves. It's typically a record of what the other parent did. And so what Jack recommended is you say, okay, each of you could give me 10 pages. And so that you're not stuck reviewing hundreds of pages that kind of say the same thing of like, we got in a fight today. And the big key here is to try to treat everyone the same so that you're not showing any sign of bias, right? Because that's going to call your report into question. So that's again like, okay, you're going to give me 10 pages. You also have the opportunity to give me 10 pages. And then you're going to do psychological and testing, which is really interesting because we do so much research and careful thought and careful training on the psychological testing. But in these particular evaluations, this is actually the least important source of information. It gives us some general information, so they are typically done. So usually they'll use the MMPI, whatever version of it is, being accepted at this time. So one study found that 84% of child custody evals gave the parents the MMPI, or maybe some other personality tests. And on the MMPI, you need to be aware of certain things. So for example, we know that there is defensiveness, right? And the ideal situation is that both parents want the child, right? If someone is not coming across as defensive or doesn't seem like they're fighting for the child, right? Like that in and of itself can be sort of work against them. So when both parents want the kid, They're both going to be defensive and try to present themselves in the best light. And this is so common that if people are not defensive, you might have to worry about that. Maybe it means they don't want custody, or maybe it means they're so psychologically disturbed that they don't pick up on the fact that they should be trying to make themselves look good, right? So the MMPI and other evaluations actually have separate norms you use for custody evals that take this into account. So for example, that L scale I mentioned before, the lie scale, the fake good scale, it has higher cutoffs in this population. And that's the one that has questions like, I read the paper from cover to cover every day. Like no one reads it literally from cover to cover most of the time, right? So things like that. So you want to compare it to the norms and the studies, particularly done on custody evaluations. There is also limited research concerning the MMPI and parenting in particular. So we don't know much in general about how psychological evaluations predict effective parenting. And that's why things like records reviews and interviews and those observations are really helpful because, again, as we mentioned, we were talking about risk assessment. The best indication of future behavior is past behavior. So what are these relevant characteristics that we want to look at in the parents and sometimes in the kids as well? So we have relevant clinical characteristics, and none of these necessarily preclude custody. They're just all things you want to keep in mind. And these relate to providing for this child's specific needs. So if the parent themselves, we tend not to use this term diagnostically anymore of mental retardation, but developmental delay, very low IQ, that's something we need to consider in terms of like, do they understand what the child would need? Substance abuse. What's the severity? Have they been going through treatment? Sometimes it's how bad is their substance abuse compared to the substance abuse of the other parents, sadly. And then serious psychopathology. Here's what they're like clinically. Does that match with the child's needs? Right? So you could have someone with schizophrenia, which we tend to think of a very severe mental illness, but they're well medicated, they're doing well. They can probably be a really good parent. If it's a very significant problem, however, the court will usually figure it out without having to refer for a psychologist. The court can pick up on major things if the person is talking to voices or clearly can't understand what's going on, things along those lines. And so then you look at relevant personality characteristics. And these are not like good versus bad parents, they're good versus like less good parents, if that makes sense. And so experts on parenting would include these in their descriptions of effective parents. So capacity to give and receive love, empathy, being able to put yourself in someone else's shoes, emotional maturity, realizing that like the kid's needs will probably have to come before yours sometimes. But also structure, limit setting. You know, it's okay that the child like doesn't get everything they want. And it's okay for the child to have a set bedtime so that you as the parent can have some downtime, right? And not go crazy. Yeah. Flexibility versus rigidity. So are they going to keep, you know, again, some order in the house, but not by sacrificing, again, the needs of the child. The person's judgment, impulse control. If they have poor impulse control, we might worry about, are they going to just leave the child, right? Or are they going to abuse them? Things like frustration tolerance come into play there as well, and also self-esteem. So again, we could, I mean, I'm sure people could give a whole class on child custody evals that at least gives you a little indication of what we're looking at. But the next thing we're going to start talking about is personal injury. And I think this is the one where people kind of get surprised that psychologists get involved. But I'm gonna start with just some basic definitions, and then we'll start to explain why psychologists can get involved in these particular cases. So the term tort is a civil wrong one commits against another. And the idea is that some remedy is possible, and that's why you do a court case, a lawsuit typically, right? It's a legal claim or complaint in the form of a lawsuit. You have wronged me. I deserve some recompense for that. You know, take extreme cases. Everyone kind of laughed about the like McDonald's coffee case, but like that coffee was over 300 degrees, right? Like they should not have been serving that. And that person got really severe burns on their lap when it's thick, right? So things along those lines. Like I have not been able to work because of this. I had medical bills, things along those lines. The plaintiff is the injured party. They're the one who is asking the court to do something about what happened to them. And the defendant is the accused. Liability is where we determine if the defendant was legally responsible for what happened to the plaintiff. And this is the main thing the court decides in these cases. The psychologist is not involved in this stuff. This is the ultimate issue. This is beyond our expertise. When we get involved, it's clear the defendant has liability, and we'll get involved when we get to the damages. And damages are where the defendant has to do something to make rights the wrongs done to the plaintiff. So some sort of compensation, typically monetary. And this is where psychologists get involved to assess psychological and or emotional damage. And so what your assessment is going to be here is going to vary dramatically based on the referral question. So psychologists, particularly neuropsychologists, might get involved if the person is claiming a brain injury, right? And then what we would do is assess what tasks, what functions have been negatively impacted by the damage they received. It could also be, the person suffered a traumatic event. And so what have been the emotional, psychological damages this person has suffered? Do they now meet criteria for PTSD or depression, right? So we are asked to assess psychological functioning at different times, but in particular here, it's typically current, which again, much easier for psychologists. At the time we are asked to get involved, how much is this person psychologically, mentally affected by what happened? So we have a special interest in things like distress, if they've developed a new psychopathology, if there's some sort of maladjustment, they can't work now, right? Lost wages, things along those lines. And if you find these problems, the court wants to know the extent to which they resulted from the accident or actions of the defendant. And the defendant in a lot of these cases end up being an insurance company. And insurance companies try real hard not to pay money if they don't have to, right? And the dependents want you to say, oh, I can't establish a link between what happened and their psychological issues. But obviously the plaintiff wants you to say, I can see the direct connection. You okay? Did you have another question? Okay. So sometimes you will have to do retrospective assessments essentially to find out how the person changed. So what were they like before whatever happened, and how has that affected how they are now? Because it's entirely possible you get someone who comes to your office, does have problem with basic cognitive functions, does show symptoms of something like PTSD, but you have to be able to say that happened because of this incident, right? Let's say you have someone who's a combat vet, but then they also suffered a motor vehicle accident because of negligence. You have to be able to sort of parse apart the PTSD symptoms there. Yeah.
Does it apply for people who have CPTSD. Multiple.
Yeah, exactly, yeah. So, you should not be ruled out just because you already have the complex PT, you already have multiple traumas, right? If this new trauma caused you new symptoms, then that should be accounted for, but that makes the psychologist job hard, because then they have to play detective again, right? And sort of parse out the stuff from the past. And this is where, if they've already been in therapy, it's really great. You can talk to their previous therapist, you can request records. But if they haven't, it gets tricky, and then it's lots of interviews and sort of detective work, essentially. Yeah. And this, similar to some of the criminal assessments we talked about, this can be years beforehand, months beforehand, because especially places like insurance companies try to drag these out, hoping that people will just settle, or people will just drop the case because it's taking too long. So it can be a while. So you're trying to reconstruct psychological functioning from that previous time, from whatever data you can find. And so the psychologist, again, becomes a detective and has to figure out possible ways you can get information. So you're going to interview the plaintiff, their family, their friends, their neighbors, maybe their employer if they were previously employed. You want to look at records if they've had previous psychological testing. That's golden. Just because they were fragile before doesn't mean the incident didn't cause damage. That's like the better language for answering your question, actually. You can say, yeah, this person had depression, anxiety, whatever before, but this incident still caused them so much damage that like they were able to function before and now they can't. You have to be careful because there could have been impairment right after the incident, but due to the time elapsed before they get to you, it may not be as obvious or even not present. So you have to sort of figure out a timeline of what has been the course of their psychological status from really since before the incident to right after the incident till now. And they could have been impaired for some time, right? Even if they're in remission now. So if you have very severe depression, very severe PTSD, it's entirely possible you couldn't work for months, right? But maybe you got into therapy and you got better, and so now you can't. But as a psychologist, you need to sort of parse that out. The nature of the incidents alleged to cause damages. People will usually readily talk about this. And you need to look at it in terms of distress that the person experienced compared to the average person. So you want to get as much data as possible that will help determine if the distress is attributable to the incident. Again, collecting data, getting interviews, all of that. If it's a motor vehicle accident and there's traffic cam footage, looking at that. A cause and effect relationship between the current deficits in functioning and the incidents. You have to give it opinion here, but you want to do so with reasonable psychological certainty that what the person is experiencing now, that deficit, is caused by the incident. Pre to post functioning, again, taking into account any other incidents. And you need to consider alternate explanations and hypotheses. Because if you are called to testify, that is how they will attack you on the stand. So you want to demonstrate in your reports and in your testimony, if called to testify, that your hypothesis makes more sense than any other possible hypothesis. You will likely be asked to assign probability to values to your judgment. What is the probability that this particular incident caused this dysfunction? We cannot do this as psychologists. We don't have magical stats things that we can just plug in. Motor vehicle accident with these things, 50%. So psychologists should stand their ground and say, I can't do that. You can say things like, it's highly likely that your explanation is true. And this can be really difficult in things like workers' comp or within the VA service connection. A percentage is assigned there, right? So they're going to want you as a psychologist to come up with a percentage, and it's difficult. Then there's prognosis. does the person need treatment, right? They have a TBI, what sort of rehab do they need to go through? They have PTSD, what is therapy gonna look like for that? How long will that take? How much will the treatment cost? What will be the other costs in lost wages, for example, time they can't be in work? You also want to look into malingering. Especially when there's a lot of money involved, people have a big motivation to malinger, to fake, right? And this will almost always be an issue you have to address. Even if the person doesn't seem like they're malingering at all, someone's going to ask you, did you check to see if they were faking? And so the FBS, the fake bad scale of the MMPI, was developed specifically to identify people malingering in personal injury cases. So for this reason, so you can use that. Unfortunately, it doesn't work as well in identifying emotional malingering. It's more related to genuine distress. But it can be really great for defense. But if you are called to testify, part of your job as an expert witness is to educate the jury about that particular soft skill. So it gets tricky. These are ones where you're more likely to be called to testify than just give a report, because people are paying for really expensive lawyers. Really expensive lawyers have really expensive connections for things like this. All right, so your timeline here. First, you're going to get the referral, and the referral in these cases is almost always from the attorney. They're going to be like, hey, my person is the plaintiff. I need to know. I know they're psychologically damaged, but I just need you to say that, right? Things along those lines. So you'll get a basic description of the case from the attorney. And then you want to get the referring counsel and also the opposing counsel's theories and supporting facts. You will then provide information to the attorney, because the attorney is the one who's typically hiring you. So what's the scope of your practice? What's the scope of your expertise? When are you available to do this evaluation? How much is it going to cost? And the attorney-client provides informed consent and will pay a retainer for you to do this. Then you're going to review the records from both sides. These have usually already been entered into evidence, so they're public record. Then you're going to do interview number 1. So you'll notice there's more than one interview here. And this will be your brief introductory interview of the plaintiff. You'll ask for collateral information. You'll ask for contact information. You'll ask for documentation. You'll do in-office testing of the plaintiff, like the MMPI or any kind of structured interview you're going to do. And you might give them history questionnaires to take home and fill out in more detail. So these would be things like, tell me about your personal history growing up, tell me about your mental health history, tell me about the incident itself. Then you are going to review all the materials, review your questionnaires, review the test results, and review the records that that person then provided to you. And then you do interview number 2. And this is the case substantive interview of the plaintiff. So basically, you want to get all that other information first, because that's going to guide the questions you're going to ask that person during the full interview. You'll then also conduct collateral interviews, again, friends, family members, employers, everybody who could tell you information. You'll do additional interviews with the plaintiff as additional information arises. And then you'll go forward with it. So then you will review your data and your results. And you want to organize it in this particular way. Their pre-allegation history before the incident. What were their strengths and competencies? What were their pre-existing vulnerabilities? What pre-existing impairments and functioning did they have? Then you describe the trauma and distress. What was the person exposed to? What is the incident? And then you describe the sequelae, or the results of the traumatic incident. So substantial impairments in functioning that the plaintiff suffered, and ways in which the plaintiff was resilient. Then you want to look at proximate cause, impairments that would not have occurred if the alleged event, if the alleged events, the events in questions didn't happen, right? That's a big thing in the plaintiff's favor. So if you can say this person would not have XYZ going on if they hadn't had this incident. And then impairments that would have occurred otherwise. So what we were talking about already in terms of like they already had PTSD. Well, yeah, but maybe now they have more severe PTSD or they're affected in other ways. Then you have to write about the prognosis. What are the degrees of future impairments? Are they ever going to be able to work again? Right? Are they ever going to be able to drive again? So partial or complete, temporary or permanent. And what interventions and accommodations are they going to need? Or what treatment are they going to need that they're going to need help paying for? You know, this would obviously, like medical doctors would also be looking at if this person also had physical injuries, right? So now this person is wheelchair bound, so they have to retrofit their house, right? Things along those lines. And then you have your conclusions, and these are your opinions and recommendations. And here it's a good idea to consult your colleagues as needed. You might need to consult with the retaining client attorney. And then a written report if it's requested. Like everything else that we've talked about in this class, this will be examined with a microscope. So you have to be a really good writer and a really careful writer to succeed in these types of evals. You need to be prepared to defend every sentence of the report. One little thing, one little typo can destroy your credibility. And less is better. You want to make everything concise and clear. Then there's a step called discovery. And the first step of this is a subpoena, where the other attorney will ask you to send them everything you've gotten out of your assessment. And then the second step, excuse me, is a deposition. And you are ordered to appear to be questioned by other lawyers. Typically, the plaintiff's lawyer is also there. This is similar to testimony in court. You are under oath, but there's no judge, there's no trier of fact. So for that reason, you know, we've all seen law shows where the attorney asks a crazy question and someone says, I object, and the judge says, you know, sustained. And so then they can't ask that question. So the attorneys can ask whatever the heck they want, right? The other attorney can object, but then you still have to answer. And this is the stuff I know pretty intimately, unfortunately, because I have been deposed in a case before. There's a case we'll talk about when we talk about sexual violence that occurred on our campus, and she was my advisee. And so they called me in to testify. And it was really interesting because they called me in to testify about sort of like what her academic fallout was from it. But then like the opposing attorney tried to start using me as an expert witness too. He was like, oh, well, you've done XYZ and you've published this. And I'm just like, I don't use any of this in court, but I still had to answer, right? So the college's lawyer had prepared me very well. And so I was able to talk in a supportive way about her, but also say when I didn't know something. The one that really got to me, and I don't think would have been allowed in the court, was the opposing lawyer said, well, don't you think that students just sometimes change their minds and then they say they were raped? And I was like, so ticked off. But they had told me, like, you can't get mad, you can't yell at people, right? You don't want to perjure yourself, blah, blah, blah. So the whole time I just like sat like this, because you all know how much I gesture. And I said, you know, my students just don't talk to me about stuff like that. I was just like, that's the only safe answer I can give without ranting on you. When I left, I was just drenched in sweat. So this can be stressful, but particularly if you do it more often, I think not as much. And you want to be very careful what you say in the deposition, because you have to say the same thing in testimony. And also because you are under oath, you can technically perjure yourself if you say something that's an unintentional or intentional lie. Once you get to that point, only 1 or 2 cases out of 10 will go all the way to court. Usually there's some sort of settlement that's agreed upon before you go to the full trial. Again, in these cases, you might often be called to testify, and you have to be very realistic about your own credentials and expertise. You don't want to stretch or overstate. And this is making me laugh because one of my other professors, Yossi Ventura, told us a story about he was called in on as an expert witness, not as he hadn't done any eval, but to talk about the MMPI, because in this case, the person's attorney, I think, had given the MMPI by reading it out loud, which is not cool. And apparently the lawyer that hired him spent like a good 5-10 minutes just like pulling out articles and books and like, Dr. Raporas, did you write this? Did you write this? To try to like establish his credibility. And the court sketch artist at the end of the trial gave Yossi a picture of him just like surrounded by all these books. So you want to establish it, but you don't need to be that elaborate, right? Saying you're a PhD, if you're board certified, that's great, right? Things along those lines. You want to always be honest. If you don't know and you're not sure, you say that. And if you don't understand the question, you don't understand what you're being asked, you say that. You ask them to repeat or clarify. You also don't want to volunteer anything. You just answer the question you're being asked. Your role is to provide information to that lawyer that retains you, or the lawyer from the other side who's questioning you, and just to answer their question, not to go on like a whole thing. See where we're at here. I'm not sure if we can get all the way through workers' comp evals in 10 minutes, and I don't want to sort of end weirdly in the middle of it. So we will start with those on Thursday. No, today's Thursday, Tuesday. I don't know what day it is, y'all, anymore. And everybody have a good weekend. Enjoy this weather. It's lovely.